Welcome, everyone, to the Illusion of Consensus podcast. I'm Professor Jay Bhattacharya, and I'm absolutely delighted to have here with me my good friend, Aaron Kheriaty. Dr. Kheriaty, thank you for joining me. Aaron and I are co-plaintiffs in the Missouri versus Biden free speech case, which recently was at the Supreme Court, where we experienced the loss. There it was called Murthy versus Missouri. And this podcast is about both just to understand what that loss means for free speech in America, what the case, where the case currently is, and actually at the end of this, I think, cause for some hope. Aaron, welcome to the show. Thanks for coming.
Great to be with you, Jay. And I would actually say what we experienced at the Supreme Court is not so much a loss as a temporary setback, because a loss would suggest that our case is over, whereas in fact our case is still moving forward in the district court. And the temporary setback in terms of the Supreme Court not granting the preliminary injunction that we had requested, actually, even that is not a permanent decision. I think, as we'll talk about in the course of this podcast, we're going to have another shot at getting that preliminary injunction upheld by the Supreme Court sometime in the next year. So our listeners don't lose all hope in our legal efforts. I prefer the term temporary setback to a loss, although it did in the moment feel like a loss because we didn't really get the answer.
Yeah, I have to confess, I was quite depressed for a little while.
We didn't get the answer we wanted from the court, but I think it's important to emphasize that the case is not over, and even that issue of the preliminary injunction is not necessarily over either.
So, okay, why don't we start with a recap of the case, and maybe I'll start just with my little experience about how I got involved in the case and what it was about, and then you can chime in when I get something wrong, which is often. The case, from my perspective, it started in something like August 2021. The Missouri and Attorney General's office reached out to me, told me that they were interested in filing a lawsuit against the Biden administration because their theory was that the Biden administration was coercing the social media companies to censor me, to censor voices like mine, and they wanted somebody who had been censored, who very prominently had been like suppressed during the pandemic. I had been working with their office actually before that on a whole variety of like anti-lockdown, anti-mandate cases, so they kind of knew about me, and I actually explored previously some avenues to maybe sue the social media companies or the government or something because there'd been documented cases of, for instance, the Great Barrington Declaration being censored by Facebook, Google searches being suppressing Great Barrington Declaration, a whole bunch of like sort of concrete evidence that had come up before. But every lawyer I talked with said, "Well, this is not going to work. Like the Twitter and all those social media companies have protection against this kind of lawsuit. They have these like Section 230 protections. Section 230 of the Communication Decencies Act essentially says that they can set their own policies for what they promote or not promote, show and not show. Even though they're not publishers, it says that you can is that they can't be sued for defamation or something like that. So they can, it sort of protects them against like lawsuits because they allow somebody to publish something defamatory online, for instance. Anyways, I talked to a bunch of lawyers and it just seemed hopeless. But then when the Missouri Attorney General's office says that they're interested in it, I mean, that's a whole separate thing, right? Like you get the power of a state suing the federal government. That's a very, very different proposition. So I jumped at the chance. So that must have been something similar to what you went through.
Yeah, exactly. They reached out to me around the same time. I think we came on board as co-plaintiffs around the same time that we got Martin involved. I think shortly thereafter, Jill Hines came on board. So we had several co-plaintiffs as well as Missouri and also the state of Louisiana was involved as a plaintiff. And the key, as you just suggested, the key to this case was that we are not going after the social media companies. We can argue and debate about whether Section 230 is a good law, whether they should have protections from liability, and if they get those protections from liability, whether they should be subjected to being considered a common carrier and not be able to censor. Those are, I think, really important debates. And it's a really important legislative issue, maybe how to fix some of the current problems with Section 230. But bracketing that, nobody doubts that legally the federal government itself cannot censor. And so what we were alleging in this case was that the censorship was not just coming from Twitter or Facebook. It was being done by Twitter and Facebook, perhaps, but at the behest of the government. And the government was pressuring, coercing, inducing, browbeating, threatening these companies to do its bidding, which we're alleging is a violation of our First Amendment right. So setting aside, what the companies should and shouldn't be able to do, the federal government cannot, under the First Amendment, suppress our free speech. In the language of the First Amendment, the federal government cannot abridge free speech. It cannot do anything to lessen our ability to say what we want to say in the public square. And that's what I think we have plenty of evidence now and discover in our case that is exactly what is happening, which is why the district court issued a temporary injunction against the government at our request. That was upheld by the Fifth Circuit on appeal when the government appealed that decision. The government appealed again to the Supreme Court, and then we sort of got our temporary setback on a technicality where the Supreme Court in a 6-3 decision alleged, I guess I would say, that none of the plaintiffs, either the two states or the 5 private plaintiffs in the case, had standing to bring the case. And the basic idea behind standing is that, let's say Congress passes a bad law that we think is unconstitutional. Let's say the government official does something that we believe violates the Constitution. The person bringing that case to the court has to allege that they personally have been harmed by that action, right? So it's not enough for any old citizen to raise their hand and say, I think the law that Congress just passed violates the First Amendment of the Constitution because it permits censorship. So I'm going to challenge that law. The person challenging that law in court always has to, the court cases have to be based on cases, as it were. They have to be based on instances where an individual or an institution, if it's the state of Missouri, Louisiana, is harmed by the government action. And if you can prove I was personally harmed by this, then you have standing. In other words, you have the ability to bring the case.
So there's a couple of things that are really interesting about that. So first of all, none of the plaintiffs in this case were seeking monetary damages, right? None of us were seeking, trying to get money from the government to compensate us for our rights being violated. The main thing we were seeking was an injunction against the government from violating ours and other people's constitutional rights.
That's exactly right. And in a sort of ironic twist, the Supreme Court in its decision suggests that if we were only seeking damages for previous harms, perhaps we would have had a stronger case. But in trying to issue a temporary injunction, we also have the legal burden of establishing that we may be harmed in the future, which is an additional bar that we have to cross. And so without getting down into the weeds on that majority decision, for some strange reasons, and I would argue in the minority opinion of 3 of the Supreme Court justices who wrote a dissenting opinion also argued, Supreme Court's criteria for standing in our case was unreasonably high. What the court essentially said, what Amy Coney Barrett's majority decision essentially said was, we needed to find on discovery specific communications from the government saying that we want you to censor Jay Bhattacharya's tweet of November 4th, 2020 on, saying XYZ on Twitter. And then we need to trace that breadcrumb to the social media company actually acting on that specific communique from the government to take down that specific tweet. So the level of evidentiary burden that would be placed on this by this criteria is extremely high, and makes it such that it's almost impossible for anyone to bring a case like this.
So just so listeners understand the nature of the evidence that we found on discovery in the lower courts which agreed with us that the Biden administration was violating our constitutional rights and the constitutional rights of millions of people, including probably many folks that are actually listening to this podcast.
And that we had standing. The lower courts both agreed that we had standing as well. That was an issue that was brought up.
So what we found was not an email that said censor from the White House to the Trust and Safety Division of Twitter saying put Jay on a blacklist. We didn't find that email. What we found instead was huge numbers of emails essentially having the White House, the CDC, the FBI, the State Department essentially threaten, implicitly at least, social media companies, telling them you must censor these kinds of ideas, or else.
Exactly. The kinds of ideas that the plaintiffs were expressing and being censored.
Yes. So, like, if you say that there is immunity after COVID recovery, that's censorable. You get pressured around that. If you wrote that there does exist such a thing as vaccine injury, that's censorable. If you even things like tweeting the Great Barrington Declaration is censorable.
Yeah. And in fact, the dissenting minority opinion from the Supreme Court brought this up as a specific concern, basically saying the majority opinion almost provides a roadmap for how the government can censor and violate First Amendment rights and get away with it simply by doing, as you suggest, topic-related censorship, so long as we don't name names or we don't flag a specific identifiable post. If we just say censor anything that is favorable toward the Great Barrington Declaration, or censor anything that claims that there's infection-induced immunity following COVID, or that there are people getting injured from this vaccine. So long as you do that broad-based, topic-based censorship, content-based censorship, which is precisely what they want anyways, right? They don't just want to censor Jay, they want to censor Jay and anyone who's saying similar things to what Jay or Aaron is saying. So long as they do that, they can get away with it. And that's a very, very concerning precedent, obviously, because that would make it such that even though lots of people are being harmed as a consequence of this, lots of people's First Amendment free speech rights are being violated as a consequence of this, no one individual would be able to have sufficient evidence to claim standing to challenge this practice. And that puts, obviously, the American people in a very bad spot.
And I mean, imagine like you're just a regular person. Your ideas are suppressed, and there's no way for you to know that the White House or the CDC or whatever sent this diktat out saying anyone that posts this idea should be suppressed or censored or kicked off the platform or whatever it is, right? There's no chance of you knowing. Like they just do it silently behind your back.
That's exactly right. That's exactly right. So that's the bad news of where we're at. But actually there's some good news. And the good news is that we have a potential co-plaintiff who can meet even that ridiculously high threshold, that ridiculously high criteria for standing. And this co-plaintiff happens to be someone who's running for president of the United States. So we didn't necessarily want our case to be tangled up in presidential politics, but here we are.
Can I say about that? There's a little bit of irony here, and it's good news for us now. But we really, when we were first involved in this case, at least I should speak for myself. When I was first involved in this case, I was actually quite delighted that this was beyond partisanship. Like this wasn't a political question. This was just a straight question of civil rights. And so I think it was like last year sometime, the Robert Kennedy Jr. Legal folks who have a very similar case, sort of working its way through the the federal courts, asked to be connected with our case. Meaning that essentially they would be marked as co-plaintiffs with us. And I was opposed to that, actually. I mean, there's a lot of irony here because at this point, I'm really, really glad I lost that argument. Yeah. But I was opposed to that because I didn't want people to view this as a political case. I wanted people to view this as a civil rights case. But of course, RFK Jr.'s civil rights have been violated by exactly the same censorship complex that violated our own rights.
That's right. And fortunately, the judge disagreed, with us and decided to enjoin those cases, decided to combine the cases. So his case was filed in the same district court in Louisiana, I think by design, by legal strategy, with the idea that the cases might be combined. And the advantage of combining the cases, both now for him and for us, from our standpoint, he is now considered, as it were, a co-plaintiff. And all it takes is one plaintiff in your case to have standing in order for the entire case to move forward. So we don't have to prove that I have standing and you have standing and Martin has standing and Jill has standing. We only have to prove that one of us has standing according to their criteria. And then the entire case and all the documents that we got on discovery can move forward. from his standpoint, by combining the cases, he is allowed to use all of the 20,000 pages of documents that we already got on discovery, all 6 of the depositions that we've already taken of various defendants. And as it turns out, in those 20,000 pages of documents that we have on discovery, we have several communications between the government and social media companies specifically flagging posts from RFK Jr., sometimes identifying this specific post. So, for example, I think around the time of the death of Hank Aaron, who died suddenly, RFK Jr. posted nothing definitive about, I know with certainty that he died from a vaccine injury, but just raising the question. He, like many other athletes, suddenly dropped dead, and we're wondering about his vaccine status. And this kind of raises questions about what's going on with these athletes dropping dead all of a sudden. It was sort of just asking a reasonable question. That post was identified by the government and flagged for takedown. And then we had back and forth communication between government and social media companies, where the government's pressuring the social media companies to take that and other RFK Jr. posts down, and getting angry when it's not done. And then finally the social media companies caving. So long story short, even by the extremely high, strict, maybe unreasonable criteria for standing that the Supreme Court has established, it seems like RFK Jr. will meet that criteria. So long as he can use the documents that we have on discovery, he can prove that he has standing. And then the combined cases, his and ours together, which are essentially the same case, alleging the same things, are going to move forward. So here's what I anticipate is going to happen.
Actually, before that, I just want to just explore that for just a second. So it doesn't matter that the Supreme Court has ruled that the plaintiffs, me, you, Martin, Jill, do not have standing. That makes no difference if somebody enjoined to our case has standing, because by that
Correct.
point, you now hear the case on the merits, regardless of the standing is just like a test that you have to pass. And if at least one of the members of the plaintiff's party passes the test, then you're done. You don't have to consider standing ever again. You just
That's exactly right. Standing is your ticket in the door, right? And essentially what the Supreme Court said is the Supreme Court did not deny that censorship was happening. The Supreme Court did not rule against us. They didn't look at the evidence. They said in the majority opinion, we don't have to look at the evidence. We don't have to rule on the evidence. It's
really funny that majority, it says it's only standing, nothing else. We're not saying that the Biden administration had the right to violate everyone's civil rights. These guys didn't meet the burden of showing that they'd been violated.
It was a method of temporizing. I think the Supreme Court didn't want to deal with the issue in an election year. They didn't want to get entangled in a case where they might have to slap down the executive branch of government, including the current administration and several people working for the White House. And I mean, Supreme Court doesn't want to get entangled in politics in that sense. And so I think this was a way of them saying, oh, we don't have to look at this right now. Right. If somebody else brings a case that, can get their ticket in the door, then I guess we'll have to deal with it. So that's my reading on what the Supreme Court
so
did.
Now RFK Jr. joins our case. They even ruled that Jill Hines, who with their emails saying,
amazing,
censor Jill, that apparently she wasn't enough. But they also say that they didn't read the evidentiary record. All those 20,000 pages, the majority opinion has this footnote, this absolutely shocking footnote, I think, that essentially admits that they didn't look very carefully at the entire evidentiary record before rendering an opinion.
That's right. They only looked at the standing issue. I think it'll be impossible to say that RFK Jr. doesn't have standing. If they want to punt, if they don't want to deal with the case, they'll have to come up with they'll have to invent some other technicality. I don't know what that would be. I'm not a lawyer. I guess they're creative. Maybe they could do it. But I think, so essentially the district court judge issued an injunction, the same injunction in Kennedy's case that was upheld by the Fifth Circuit in our case. But he said, I'm going to put a hold on that until 10 days after the Supreme Court rules to see what happens when the Supreme Court rules. So the Supreme Court ruled in our case, and then that injunction was going to go into effect. And the government stepped in and appealed that to the Fifth Circuit. The Fifth Circuit just recently made a ruling basically sending that injunction back down to the district court, telling the district court, consider this injunction in light of the criteria that the Supreme Court has established in our case in Murthy v. Missouri to see if basically he meets the standing criteria. So the district court is currently considering that. Here's what I anticipate that will happen. The district court will say, yes, even by the Supreme Court's novel extremely high standing criteria, Kennedy qualifies. They'll issue the injunction. The government will appeal to the Fifth Circuit. The Fifth Circuit will uphold it. The government will appeal again to the Supreme Court. And when the Supreme Court comes back in session soon, they're going to hear the case in their next season. They're going to have to rule on it at the very latest June of next year. So in less than a year, the court's going to, I think, have to look at the evidentiary record and rule in the case. And I don't see how they rule against us.
So let's just explore this for one more twist on the legal aspects of it. All of this appellate hearings about the case, like the Fifth Circuit Court of Appeals and the Supreme Court, it wasn't actually on the case per se. The case itself, it still has not yet been heard
Correct.
In full.
This is all on the preliminary injunction, which is basically what is a preliminary injunction? It's us saying, even based on the documents we've gotten so far on limited discovery, we'll have more discovery as the case goes to trial. We'll have more documents. We'll have more depositions that we take of defendants that the court will allow us to do. But even with the limited information that we have so far, we have so much evidence that the government's violating the First Amendment that rather than waiting another year or two before we get a final ruling in this case that's going to be dragged out by appeals and so forth, we think that the violations are so severe that the court has to step in now and put a stop to it. So it's actually hard to get a preliminary injunction. There's very high legal criteria. You can be denied a preliminary injunction and still prevail in a final ruling in the case. That's quite common, right? So it's a high burden to get a preliminary injunction. And all of the appeals so far have just been on the preliminary injunction. Our case now is moving into the trial phase where we will get additional discovery, and there's going to be a lot more adversarial back and forth. And you and I will give testimony, and there'll be the courtroom drama that people think about when they think about a civil court case, right? It's going to be awesome. It's going to be great. But so far, the Fifth Circuit and the Supreme Court appeals have only been on this question of the preliminary injunction.
Right. So that means that the case, even after it goes back up to the Supreme Court, if everything goes as you predict next year, that will still be about the preliminary injunction.
Correct. Correct.
In the meantime, the case will still be being heard in Louisiana.
And as we move forward and get more documents on discovery, we will also be requesting more documents that could potentially establish that one of us has standing according to that, very, very high criteria. So we're going to continue looking for those breadcrumbs and looking for, where in the government communications is Great Barrington or Jay or Martin specifically named, right? And so there's two possibilities on the standing question. Number one is that we establish that we have standing based on getting additional information that meets that stringent criteria. Or number two, Kennedy, in his enjoined case, establishes that he has standing, which allows both of our cases to move forward. And I think the latter is almost certain to happen based on just the specificity from the government to the social media companies, naming him by name, calling out specific posts by name, complaining when the government or when the social media company didn't act quickly enough on those specific posts. Why are these posts from Robert F. Kennedy Jr. still up on your platform? If that doesn't establish standing, then nothing will, I think.
So before we move on, there were a bunch of fantastic reader questions or listener questions about this that in anticipation of our recording this podcast. Which I want to get to. But before we hit that, there's a couple other points I wanted to discuss. One is this issue of have we shown future harm? Like, is it the case? Okay, so fine. The Biden administration suppressed us in 2021. So what? Is that enough? Is that enough to say we because they're no longer suppressing us, and there's no in fact all these New York Times articles are swearing up and down that they've stopped doing it. They've chilled. We've chilled the censorship industrial complex just by the very fact that we have brought this case. and therefore there's no harm going on now. I worry about that argument because if a government can suppress people for a time, and then when they're caught, stop suppressing them, and then there's no like consequence to that. What's to stop future governments from just doing that over and over and over again?
To me, that this was the most disappointing aspect of the Supreme Court's majority opinion. And it was disappointing because the Supreme Court just took the government's claim at face value without any evidence that we're not doing this anymore. And in fact, right after the oral arguments, the government started rescheduling all its regular meetings with the social media companies that it was having before to basically facilitate this censorship. So as you said, they sort of backed off, at least in the more public aspects of what they were doing. They backed off, or they gave the appearance of backing off while we were waiting for our case to be heard. And then as soon as the oral arguments were finished, they started up again. But the court took their claim at face value that we're not doing this anymore. And so that even if we may have harmed them in the past, we're not going to harm them in the future. And it just seems wildly implausible to assume without evidence and just on the word of their lawyer that they're not going to do that anymore. And in fact, I think Barrett should have known better, because the last question that she asked of the government's lawyer in the oral arguments was, are you claiming that this case is moot? That the issue of the injunction is moot. What does that mean? Moot is a legal term, basically, that means that the thing that you're challenging is no longer happening anymore. Therefore, you don't need to challenge it anymore. So say you're challenging a law that was passed and the legislature reverses the law and changes it. Then the court could declare, okay, your case is moot because the law is no longer the law anymore, right? And when she asked that, the government lawyer said, no, we're not claiming the case is moot. It was the context of him arguing we're not censoring them anymore. Well, essentially what he was admitting was, we're not promising that we're not going to do this in the future. Right? We're not promising that this behavior that they don't like is not going to be an issue in the future. So I think based on that question alone, that should have tipped the justices off to the fact that the government had no intention necessarily of backing off. And if they thought that they could get away with it, then they would. And it's this sort of catch me if you can game. As you said, there's nothing stopping them from doing this in the future, so long as there's no injunction in place. And in fact, going back to your initial remarks about this being a nonpartisan issue, I would tell anyone who's worried about the possible election of Donald Trump and not wanting Donald Trump to exercise power as president, what I would say to any that would be opposed to a Donald Trump presidency is, there's nothing stopping Donald Trump from firing all the people involved in this censorship regime, putting his own people in those positions, and using the exact same machinery to continue censoring, but just censoring in the direction that he wants the censorship to go. So regardless of who you're going to vote for in the next presidential election, regardless of whether it's going to be Biden or Kamala or Trump or whoever holding the levers of power, I think all Americans should be able to agree that the government should not be able to censor us. Maybe you like the direction that the censorship is moving right now. Maybe it's conducive with your political or your ideological views, but the shoe could be on the other foot in a year or two. And I mean, that's why it's so important for us to defend these rights and to defend the right of people with whom we have disagreements to nonetheless exercise their First Amendment right of free speech, right? It's easy to defend the free speech of people with whom you agree, by and large, right? It takes more integrity to defend the rights of people with whom you disagree, people who are advocating positions that you don't like. But that's precisely where the rubber meets the road. And I think even from a self-serving standpoint, it makes sense to do that, just given the fact that the political winds shift, right? And the people in power shift. And the shoe could be on the other foot. So if you don't defend the rights of the other people when they're going after them because, hey, it's not impacting me personally, or maybe I don't like those people or whatever, I don't like what they have to say. If you don't stand up and defend the free speech rights of those people, one day you're going to find yourself in that position and, wishing that those folks would come to your own defense. So it's not a partisan issue. This is an issue of all Americans.
It's such a persuasive argument that I don't understand how people who are currently favor censorship could not see it. So let me just before we get to the listener questions, I want to explore one more thing along that line. And I think this is actually quite important to me. I suspect to you also, Aaron. What we were saying, that the ideas that we were expressing, me and you were expressing, were not actually wrong. We were actually calling out the government's misinformation.
That's right.
Right? There actually does exist immunity after COVID recovery. Right? The vaccine mandates do actually induce skepticism about other vaccines. Right? There actually were people harmed by the vaccine.
Yeah. Lockdowns did have downstream negative consequences for society. School closures did turn out to harm children's development. I mean, all of these things are now, I would even venture to say, conventional wisdom. I'm seeing far, far fewer people. There are still some, without a doubt, but virtually no one defending school closures. Far fewer people who would defend prolonged lockdowns. The CDC itself came out after I was fired for basically putting a stake in the ground on this came. The CDC itself came out 9 months later and said we shouldn't discriminate between vaccinated and unvaccinated for two reasons. Number one, the vaccines don't stop in infection and transmission. And number two, infection-induced immunity is robust and probably longer lasting than the immunity from vaccines, which is exactly what I was saying when I was censored. That's exactly the content that I was censored on. And then, my only crime was being 9 months ahead of the CDC and whatever conventional wisdom from mainstream public health. So we were censored not because we were wrong. We were censored because we were right, and being right, we were threatening to the government's position because the government was advocating harmful public health policies, and they didn't want those policies to be challenged by credible individuals.
Hi, everyone. A quick word from our first and exciting sponsor, Alchemy Elements. Alchemy Elements is a powerful adaptogenic supplement. For those of you who don't know, adaptogens are a class of plant compounds, primarily herbs and mushrooms, which can help build the mind and body's resistance to stress. Alchemy Elements contains a very unique and carefully selected blend of 9 adaptogens, such as lion's mane, cordyceps, polygalaroot, and shilajit, and they can help boost energy, boost your immunity, and increase focus and overall stabilize your mood. It can have a wide array of effects, which can often depend from individual to individual, but it's a great way to start your morning and generally increase your focus and your energy levels. You can just pour 1 scoop of Alchemy Elements into your morning coffee or your protein shake or smoothie, and you're off to the races. It's a great way to start the day. I use it every day. I find that it can generally stabilize my mood levels and increase focus, especially if I want to get a big project done or finish a very important task. Alchemy Elements often is a great way to kind of start and get my focus going and get me primed for whatever task I want to accomplish. We're very excited and very happy to work with Alchemy Elements. We've been working with them for a couple of months, and now in this new iteration of the podcast, we're going to continue our relationship, which is very special to us because Alchemy aligns with our mission and values of individuals taking greater ownership of their personal, mental, and physical health and relying less and less on corrupt and flawed, generalized kind of medical advice. And less reliance on pharmaceutical drugs, and more of a general interest and focus on holistic health. For a limited time, Illusion of Consensus readers and listeners can get 10% off their first order using the code word illusion, or 30% off a subscription monthly order, where you can get a monthly shipment of Alchemy Elements delivered to you. For these subscription orders, you can also get with it a bonus gold kit to store your Alchemy Elements. Overall, I think Alchemy is a fantastic product. I highly recommend you check them out in the link below in this podcast, wherever you're listening, Spotify, Apple, Substack, Rumble, or YouTube. Just go to the link, use the code word illusion, and you can get your discount and you won't regret it.
The psychology of it is really important, I think, here, right? So I think listening to the oral arguments, it was clear to me that many of those folks on the court who voted against us didn't understand that basic point.
That's right.
They thought that we were fringe figures that were saying crazy things, not that we were actually correct. Like you could hear it, for instance, in Judge Kentucky Jackson's hypothetical of, well, what if there's a social media craze of kids jumping out of windows, then they film themselves and dare other kids to jump out of higher and higher windows. Shouldn't the social media companies and the government be able to force social media companies to stop that trend from happening to save the lives of kids? In fact, the premise of it is exactly backwards. It was the government that was harming kids, and it was we who were trying to get the government to stop harming kids by, for instance, opening schools back up.
Exactly. Exactly. The government was telling people to jump out of windows, and we were trying to put a stop to it. So no, I that's exactly right. That underlying assumption was there. And if these were perfectly unbiased legal minds, it shouldn't matter who was right and who was wrong, right? So from a strictly legal standpoint, the government cannot censor even false information, right? You have a right to be mistaken. You have a right to conjecture something that turns out not to be true without being censored by the government. But it bears saying in this instance that we were right. And that should psychologically help people see the problem with what was going on. So strictly speaking, it shouldn't matter one way or the other legally. The government is not the arbiter of truth. The government is not empowered to decide what is true and what is false, to decide between debates about lockdowns and school closures and vaccine mandates. They're not qualified to do that, and they're not. One of the reasons for the First Amendment is to recognize that no one individual, no one institution can and should be an arbiter of truth in all circumstances, because that power is always going to be abused. It's going to be used in self-serving ways. People are biased. Institutions are biased in their own interests. And that's why we need the free play of ideas, the free market of ideas, if you want to use that metaphor, is the best way of getting at the truth. But with all that said, we can't repeat frequently enough, not because we're trying to be arrogant about it, but just because, we were right, and we're winning those debates today, I think. And people are coming over to our side, and people are rejecting the side of the positions that were trying to be defended by people engaged in censorship.
And let me make a further point on that. The purpose really of the censorship isn't even actually to suppress people from hearing our ideas. I mean, that is a purpose, but that's not the primary purpose, actually. Right? They're like they could try to suppress the internet, but it's very difficult. Like anyone can go on any corner of the internet and find some idea. Like that's not. It's like trying to stick your fingers in a leaky dike, and there's like water coming out of a whole bunch of holes. Like it's not possible. The real purpose was essentially to put a cloud above our heads.
That's right.
And say, look, these people are misinformers. These people are deserving of censorship. These people deserve to be suppressed and put to the fringes of society.
Yeah.
Right? Is to cast a cloud of doubt over us and our ideas. And in that, it was quite successful.
I think that's exactly right. It's to marginalize you. It's to send you to a disreputable corner of the internet, away from the mainstream, where that's the only place where you can get a hearing, in order to make you appear marginal, in order to maintain what some people have called the Overton window of acceptable opinion. And in fact, this is exactly what totalitarian regimes do, right? All totalitarian regimes engage in censorship. Eric Voegelin, the 20th century political theorist who studied the totalitarian systems of the 20th century, said the central feature of all these systems is the prohibition of questions. The regime monopolizes what counts as knowledge, what counts as rationality, what counts as, the opinions that you're allowed to hold. And if you raise your hand and ask any inconvenient questions about lockdowns or school closures or vaccine mandates or whatever, you are silenced, you are marginalized, you are placed in a literal ghetto. In our case, you're placed in a kind of digital ghetto where, you can still write your thing. You can still get on some, fringy podcasts and say what you want to say, but nobody can find you on a Google search. the stuff you try to post on Twitter or Facebook is going to be flagged or taken down or, somehow throttled. And that has exactly the consequence that you just described of discrediting and creating this cloud over you that, he's still out there and he's still saying his thing, but we don't need to pay any attention to what's going on over there.
Yeah. Even if we're right. And, of course, then there's Wikipedia, which will grab on to those sources that are most susceptible to that kind of censoring and producing of those reputational harm and amplify it.
Right. Well, Wikipedia is now a creature of the intelligence communities in the United States. They have basically gained complete control over that, that particular source of information. So Wikipedia is very, very seriously compromised in the interests of, what some people have called the deep state, but, you don't have to sound conspiratorial about it. What does that mean? In this case, it's literally the intelligence communities in the United States and the way in which they have from their very founding, post-World War II, tried to engage in information control globally. And they're now doing it domestically as well through places like Wikipedia.
Okay. So let's get to the listener questions, the reader questions. So I picked 4 of them, which I thought would be really interesting to us. So the first is from Maria. And she asks, how did Barrett, Justice Amy Coney Barrett, who wrote the decision, the majority decision against us, how did Barrett even get to the plaintiff did not demonstrate standing? That's the question. Your First Amendment rights were violated when Twitter silenced you. Twitter is a public platform on the internet that enjoys Section 230 protections. Yet Twitter acted like a publisher when they downgraded your accounts. Of course, I was put on a blacklist. I suspect you were too. Although I get to see it with my own eyes at the Twitter headquarters when Elon bought Twitter. So how did she get to this idea that we don't have standing?
Many legal commentators have pointed out that denying plaintiffs the ability to move forward on issues of standing has become more frequent and commonplace in federal court in recent years. And many legal commentators claim this is a way for courts to punt or to avoid dealing with thorny issues that they don't want to deal with. So you can reach for this sort of technicality as a way of just kind of shoving a case aside, right? So I don't want to impute motives on 6 of the Supreme Court justices, including Barrett, who wrote that opinion. I don't know what her motives were. I don't know why she decided we don't want to look at the evidence.
Motives aside, they came up with a set of rules that we had to meet.
Yeah.
And those rules seemed like they were quite strict. Is that the normal set of rules you have to meet for standing?
Well, according to Justice Gorsuch and Alito and Thomas, who wrote the dissenting opinion, they invented a new set of rules. I mean, that's what the dissenting minority opinion actually claimed, that these rules are too strict, that it's an impossibly high threshold, that it creates a map for how the government can continue to censor simply by not naming names, all the things that we've talked about already. So, I mean, you don't have to take my word for it. At least 3 of the Supreme Court justices believe that the criteria for standing in our case was created de novo out of whole cloth, that there's no precedent for establishing this criteria for standing in a free speech case like this. Granted, our case is novel. Right? It's the first case of this kind of social media censorship in the digital age that involves government actors, right? So I guess, like, to give the devil his due, the court is going to have to come up, they're going to have to think in new ways because it's a totally new issue that the court has never faced, right? And so the circuit court admitted, we looked for a Supreme Court precedent for this case and we couldn't find one, right? And so this case is unprecedented in a literal sense of the term, in which they're looking back to citing cases like Bantam Books, which had to do with a small bookseller in a small town. It didn't have to do with Twitter and Facebook and, social media companies that reach literally billions of people, right? Which with hundreds of thousands of users posting content who may have been censored. So this is an unprecedented case. They invented criteria for standing that all of us plaintiffs certainly think is unreasonable. And at least 3 of the Supreme Court justices said this is entirely unreasonable.
I mean, and on the merits, of course, those 3 are the only ones that like weighed in because they didn't.
Yeah, they clearly looked at the evidence, and they were clearly very concerned about what they saw, as were the other 4 justices that have looked at our case. So we have a district court judge and a 3-judge unanimous panel at the Fifth Circuit. All of the ones who have looked at the evidence have said, this is really bad. And the language they've used to describe how bad it is kind of staggering.
It was beautiful.
Right?
Ministry of truth, right? That's what the
Orwellian Ministry of Truth. That was the language of the district court judge. This is, if what plaintiffs allege is true, this is arguably the worst free speech violation in United States history. There was a federal judge who said that about our case. Arguably the worst violation of free speech rights in American history. The reason it's the worst is because it impacted so many people because of this technology.
So the second half of Maria's question is an assertion. It says, your First Amendment rights were violated when Twitter silenced you. Twitter is a public platform on the internet that enjoys Section 230 protection, just like we talked about earlier. Yet Twitter acted like a publisher when they downgraded your account. What do you think of that?
So I think that's right, but that's not current. That hasn't currently been the court's interpretation of Section 230. So just a little bit about Section 230. Section 230 was designed so that the social media companies wouldn't be liable for slander, defamation, because there's no way that Twitter and Google and YouTube and so forth can monitor and edit all the content that they publish in the way that the New York Times could. Right? The New York Times publishes a defamatory opinion piece. They can be sued for defamation. That makes sense. I think most people would agree, like the social media companies couldn't function if they had to take on that degree of liability. Fine. But the other thing Section 230 did, whether directly or indirectly, intentionally or not on the part of the lawmakers, was to also give them editorial control. And this is where I think we have a serious problem with Section 230. And in fact, at one point, Chief Justice Roberts, during our oral argument, sort of hinted that maybe Section 230 is the problem here. That was a kind of an interesting wrinkle. It was almost an aside that remark that he made at one point during oral arguments. But the problem is, like the New York Times and the Washington Post, even though they're immune from all liability for what they publish, they're also given editorial control over what they publish, which means they can censor, which to me is a problem. So when the New York Times decides not to publish my opinion piece, they're not censoring, they're exercising editorial control, right? They don't have to publish anything and everything that someone submits to them for publication. But my view is, if we're going to protect the social media companies from all liability, then they're not publishers. They should be considered what's referred to in the law as a common carrier, meaning they're just like a public utility. They're just like a conduit. They're like the telephone line. But the telephone company cannot censor what we say when we have a telephone call.
So just to push a little bit on this argument, what about child porn? What about physical threats?
Great question. So my view is that as a common carrier, they would be subjected to the First Amendment, and they would be given permission to censor any speech that is illegal. And the 2 examples that you just gave are the 2 key examples of speech that is not protected by the First Amendment. So there have been court case precedents to establish narrowly defined areas of illegal speech. Child pornography is one of them. So the social media companies would still be able to, rightly so, police child pornography in various narrowly defined forms of obscenity. They would be able to police speech that involves a direct incitement to physical violence. I add the word physical because today violence is, words are considered violent and all this. The meaning of that term has expanded. So the direct incitement to physical violence. Jay Bhattacharya lives at such and such address. I don't like him. He's a bad guy. Somebody should go and take him out, right? That is criminal speech. They're probably going to come in and arrest me for saying that on this podcast. I didn't mean it. I was just using it as an example of criminal speech. I'm not encouraging anyone to actually harm Jay. So go harm so-and-so, an identifiable person, in a direct incitement to physically harm an identifiable person or group of person is illegal speech, right? So the social media companies, if they were common carriers, would be able to police that kind of speech. But aside from that, it would have to be a free speech enterprise. So my view is that the lawmakers should amend Section 230 to clarify you can be one or the other. You want to be a publisher and you want to have editorial control? Great, no problem. But then you're going to have liability for everything you publish, which, Mark Zuckerberg has said that's an existential threat to our business model. It's impossible. Okay, you want the liability protections? We'll give you those. The way we give the phone company liability protections, for stuff that people say on the telephone, but then you're a common carrier. So I would like them not to be able to have their cake and eat it too, because it places way too much power in the hands of a small number of private actors who can exercise control over the flow of information online, which to me is a very serious problem. Obviously, it's even more of a serious problem if they're doing it at the behest of the government. Then it's clearly illegal.
There was an interesting dynamic to see a lot of the traditional newspapers and publishers come out against us, basically say that we should lose this free speech case. And of course, they enjoy all these free speech protections from a long line of Supreme Court cases.
Well, I'll tell you why they're doing that, Jay. And that's because social media is a threat to their business model. Why do fewer people read the New York Times? Well, because more people get their news from podcasts. I'm going to listen to The Illusion of Consensus rather than read the Washington Post today because I find it more credible. They get their news from Twitter, from following people that they trust. So the social media companies are a threat to traditional media. They're a threat to network news. They're a threat to newspapers and traditional magazines because there's so many more publishers out there. Now there's so many more places to get information. So I think they're opposing us not on principled reasons, but simply for reasons of self-protection. Yeah. They want other voices silenced, voices that are not on their platforms, that are not published in their newspaper. They want those other voices silenced because it's basically business competition for them, and it's harming their business. The open internet is harming their business model. I think it's as simple as that.
I mean, they internet companies, the social media companies have grabbed a lot of the advertising dollars that once upon a time flowed to the New York Times, the Washington Post, and so on.
That's exactly right.
But it's interesting, because the Section 230 kinds of reforms you talk about, they would probably favor, right? Because it puts these social media companies in a situation where they have to choose. They can either be like the other companies, like New York Times or whatever, be as a publisher, or they can just be a common carrier. And it's unlikely that they would get the kind of advertising dollars that they currently enjoy.
Yeah, no, I think you're probably right about that. Yeah, I don't know if that kind of legislation was proposed. I don't know where the traditional media would come down on that, but it's quite possible that they may be more supportive of a proposal like that for the reason you mentioned.
Okay, second question. This is from Daniel Dunkelman. Actually, I think we kind of addressed this. How can the lawsuit be continued now? Can you find standing with the current plaintiffs? And if not, can you add plaintiffs and continue it? And of course, we've answered that. In this case, we have a presidential candidate coming to the rescue, which is the irony of ironies. We have RFK Jr., who is enjoined to the case, and now the lower court is considering whether his presence in the case helps us meet the standing requirements set by the Supreme Court.
Exactly. And we will continue to pursue additional information on discovery to try to establish that we have standing as well, according to the Supreme Court's stringent criteria. So the case is still moving forward.
Okay. Third question from David Carmack, MD. If the plaintiffs involved in the SCOTUS case did not have standing, what value is having the First Amendment anyways? In my opinion, all those whose voices and opinions were suppressed by the government around COVID topics were harmed and absolutely did have standing. I have very strong feelings about this, actually, because a lot of people have argued to me that this standing thing is just a technicality. You just meet it and you're done. And I think we're going to meet it thanks to RFK Jr., which makes me really happy because the case then will continue. But the policy impact of that means that in order to, in future, to enforce the First Amendment, there's going to need to be some show of standing.
Well,
with
this is
high standard that's established.
The standing problem is a very serious problem because it puts Americans at a distinct disadvantage in terms of asserting their rights. And, one of the arguments that we made regarding standing is that all of us should have standing, even if we can't prove that the specific instances of our censorship were at the specific behest of government officials, even if we can't trace all the breadcrumbs to definitively establish that. Just the fact that we weren't able to hear other voices that we wanted to hear that were censored, that should be enough to establish our standing, because that was important for our professional work and that was important for our public opinion, be well informed by other people. And some of the people we were trying to follow were clearly being censored. So the Supreme Court has, in prior cases, said that the right of free speech includes not just the right of the speaker, but also the right of the listener to have access to information. And so the listener's rights, even if you haven't posted anything on social media, if you follow people on social media who have been censored, your rights have been violated as well, because your access to information has been limited by the government in ways that are unconstitutional. So that's a problem. And basically, in the majority opinion, the Supreme Court said, yeah, but if we grant all the listeners standing, it's going to be here comes everybody. And my response to that is, well, it should be here comes everybody. I mean, when you have millions of people whose rights are being violated, then millions of people should have the right to seek recourse for that. And if that floods the courts with lawsuits, then so much the better.
Yeah, that's
right?
their job. I mean, and the problem then is will fall on future administrations. The pressure should be on them. Stop violating people's rights. Do not censor people. You're not doing good, even if you think you're doing good in the name of suppressing misinformation. By suppressing the debate, you are actually violating the American First Amendment at scale, at a scale that's never been done before.
Yeah. So we can complain about that, but the good news is we have documents on the Discovery with spreadsheets. We have lists of people. We have lists of posts. They got down into the weeds on specifics. They did that time and again. They flagged things. They had a whole system set up, this JIRA ticketing system set up for flagging specific posts to be throttled. So somebody's going to have standing, right? They did name names, and we'll find that person, whether it's Kennedy or someone else, and other people have reached out to our lawyers. I know this for a fact. We're not going to say anything publicly about this at this point. Other people who were named and throttled by the government have reached out to our lawyers to explore the possibility of being co-plaintiffs. So there's somebody out there that the court's going to have to acknowledge, yeah, you have a right to bring this case. And then, the court's going to have to deal with it.
But that's our case. I want to make a policy point. I think that even if we win the case by meeting the Supreme Court's high standing requirements, it still is bad law, because it leaves open the possibility for the government to censor. I mean, I thought the dissenting justices did a really good job describing this. Essentially, it leaves open the possibility of the government to censor ideas with no names on it.
Correct.
And so no one will ever have standing. And so there's an enormous loophole in the First Amendment. It's essentially a dead letter. So I actually think unless the Supreme Court undoes itself on the standing question, and of course it ruled from on high that the standing question, you have to apply this very, very strict measure of standing. It wasn't even like a simple, easy one that was meetable. Unless they do that, the Congress needs to act. Congress needs to put in penalties for administration officials that violate the First Amendment, make it explicitly illegal for the administration to contact social media companies for the purpose of suppressing legal speech.
I agree 100%. I mean, legislative action could fix this issue very, very quickly, with or without the court's cooperation. A case precedent at the Supreme Court in a final ruling in our case would be very, very important to establish. But Congress can act to very, in detail, spell out the do's and don'ts. This is what you're not allowed to do. These things are clearly, going to be unlawful. And at the same time, I think they could affect some of the 230 reform amendments that would be necessary to make sure that the social media companies are not exercising arbitrary power. I think the other thing that happens is they need to break up the monopoly of the social media companies. My own view, actually, is that the government wanted monopolies. They permitted them to happen. And I think the reason for that is because it was going to be much easier for them to control 6 large social media companies that commanded 98% of the space online than if there were 30, 40 smaller companies that each had their own niche. Much, much harder to control that. That's why the internet was such a threat to government control. Governments always tried to control the new means of communication. So just a little bit of history behind this. When radio first became a new technology that people were using to communicate, the federal government established the Federal Radio Commission to license radio stations. And that allowed the federal government some degree of control over who was allowed to speak on the radio and which radio stations could have airway space. Then TV came on the scene, and the Federal Radio Commission became the FCC, the Federal Communications Commission, to also license television stations. And when you had only a small number of network news stations, it was much easier for government officials, behind the scenes to exercise influence and control over what was said on radio and on television. When you have a limited number of actors that you sort of have to manage, right? The internet and especially social media technologies were a huge threat to that, because suddenly everybody has a microphone, right? And any ordinary American, if they grow an audience and if their ideas are compelling enough to people, can basically get their voice out there and be part of the conversation. And this was a huge threat to the newspapers, to the magazines, to the networks. And also, I think now in retrospect, also to the government and their ability to try to manage these things. And so I think they deliberately allowed a small number of social media companies to occupy most of the space online in order to be able to control them. And there were instances of egregious monopolistic behavior that the government did not step in and stop. So I don't know if you remember the original shutdown of the app called Parler. Parler was sort of an alternative to Twitter. A lot of people that were being censored on Twitter were starting to move over to Parler. It was getting a reputation for being a sort of more conservative platform, but it was open to anyone. And literally overnight, Amazon Web Services denied Parler their ability to store their data on Amazon Web Services, which is what they were using. And the Google Store and the Apple Store took Parler off their app store platform. So you couldn't get it on the 2 major smartphone platforms. And it just destroyed Parler overnight. I think they've rebooted since then, but I don't think they've been able to grow after that sort of mortal blow. Those 3 companies acted in concert to destroy this app overnight, all at the same time, all coordinated. If that's not monopolistic behavior, I don't know what is, right? But nothing happened. And they all got away with it. So I think the other thing that's necessary is, number one, to enforce the laws against monopolistic behavior that are already on the books. We need a Department of Justice that's willing to do that. And perhaps there needs to be some legislative reform as well to break up some of the monopolies that the social media companies currently exercise, because you end up with this tight-knit, small number of social media companies sort of intercalated with these government agencies acting in concert, and you have this public-private sort of fascistic blob that controls everything. And
I mean,
what we need.
Fascist is actually the exact word, right? Fasces means to bind together, and you have the government intertwined with the social media companies, the private companies, not nominally private companies, essentially doing the behest of the private companies. And so the government launders its censorship activities via this private intermediary, pretending as if it has nothing to do with it, when in fact it's the central driving force.
That's right. It. Yeah, the original definition of fascism, according to Benito Mussolini and the philosopher of fascism, Giovanni Gentile, who's his ghostwriter, is literally the merger of state and corporate power. And that's what we're seeing in our case, and in what some journalists have dubbed the censorship industrial complex. This, Stanford University, the Stanford Internet Observatory, partnering with the government to not do academic research, but to basically engage in censorship and do the government's dirty work. I understand that the Stanford Internet Observatory has since been shut down. I think our case...
It's not shut down, but some of the key actors in it have now left Stanford.
Okay, yeah. I mean, our case has at least shined a light on some of what's going on and, made it maybe more difficult for them to operate out in the open. My guess is that they're not; those people are not going away. They're just going to sort of go hide in the shadows and lurk in caves that are harder
really
to
depressing.
find.
Like to use the academic enterprise as a cover for laundering government censorship seems like it's just a violation of the trust that the people place in us as academics. Like a lot of our scientific work is funded by the federal government. The federal government actually funded the Stanford Internet Observatory. I mean,
they did, and they characterized themselves as academic researchers. They were not publishing papers on disinformation or on this or that. They were flagging posts and then funneling those posts to the federal government, to CISA, the Cybersecurity Infrastructure Security Agency, and then from CISA to the social media companies to have those posts censored. So these were full-time censors pretending to be academics. They were not doing research at all.
Yeah.
They were.
They have their own journals now, so they can point to some papers, but those are not papers. Those are papers that are essentially covering up the essential activity, which is laundering government censorship.
Exactly. Yeah.
Okay, last question. And this is from the amazingly named Joan of Bark, which I absolutely love the name. So here's the question. So what about the thousands of death in VAERS? If folks had access to your expertise exemplified in your posts, they could have discerned the government's lies early on, and they would be alive today.
Well, you could say that about the information in VAERS, our government's own safety monitoring system, and you would get throttled or censored if you just drew attention to, charts and graphs from vaccine-related data in VAERS. It's a system that required additional verification of vaccine injuries, but it was a system designed to flag safety issues and designed to kind of signal things that required additional follow-up. And it wasn't used adequately in that way during the pandemic when it came to the COVID shots. And you could say that about information related to VAERS. You could say that about information related to all kinds of topics that were censored. If people had access to that information, they would have arguably been able to make more sound decisions and fewer people would have been harmed. I mean, I think censorship killed people during the pandemic. I don't think it's an exaggeration to say that. And free speech would have saved lives.
Yeah,
during the pandemic.
I mean, it's a complicated. I mean, I entirely agree with you, of course, but I do think it's complicated because there were actual lies spread around about the vaccine, about a whole host of things that were not spread by the governments. At least I don't know that there was government spreading it around, spreading those. So there were actual ideas that were abroad, available on social media, that might have misled people, right? That's actually possible. But the problem is that if you have the solution to that is not censorship. The solution to that is to have a trustworthy public health agency that says trustworthy things, so that then people, when they are wondering whether does the vaccine contain magnets or make you magnetic or whatever, they can go to the CDC and say, oh yeah, the CDC knows if it makes me magnetic, and the CDC says no, because the CDC is trustworthy, I believe them. The fundamental problem to me was then not was the lack of trust people had in public health officials, largely because the public health officials had thrown away the right to be trustworthy. They weren't trustworthy.
And precisely one of the things that would keep those public health officials honest and in check would be an openness to being challenged and the willingness to correct things that they were mistaken about, because people brought forward counter arguments or new evidence, or there was a reasonable, open public debate. So free speech itself is a corrective mechanism against institutional decay, sort of sclerotic institutions becoming entrenched in an ideological position that they can't move from, because they've killed the ability of anyone to to challenge them. And I think that's part of what happened during the pandemic. And censorship facilitated that. It's not that mistakes wouldn't have been made, but I think they would have been able to be corrected. We would have been able to correct course much sooner had we had an open environment of scientific inquiry, open debate. If academic institutions of higher education, scientific research institutions, universities had engaged in, had basically engaged in academic freedom, and allowed different voices to be heard and allowed debates to be had. But those were all stifled and shut down. And so those corrective mechanisms couldn't function during the pandemic.
I mean, the key thing here is that there's no entity with inerring access to the truth that can correct all falsehoods. And the government taking on itself that mantle essentially creates a situation where it has a strong temptation to spread lies that it's itself spread lies, just to get people to do what it wants to do.
Yeah, one good example of this, I've argued in the last chapter of my book, one of the institutional reforms that's necessary of our public health agencies, I think there are many, but I'll just mention one. The CDC had, in my opinion, two functions that were irreconcilable. They were in tension. And when they came into conflict, the CDC's ability to engage in trustworthy science became compromised. The CDC's two functions are, number one, they are responsible for gathering epidemiological data from all 50 states and collating that data and publishing it and making it available to independent researchers, or making it available to the public so the public knows what's going on with incidence and prevalence of various diseases and rates of hospitalization and rates of vaccination and so forth. So that's scientific function, number one. But they also have a public policy function of giving public health recommendations, right? We think everyone should be vaccinated. We think, we're in favor of closing schools for this reason or whatever. And they were engaged in both of these things. And when their public policy recommendations started coming into conflict with their own data, instead of revising those public policy recommendations, what they ended up doing is they stopped publishing data. So specifically what happened was initially the vaccines for the first couple of months after the shot showed better efficacy, but that efficacy appeared to wane fairly quickly, maybe 4 to 6 months for the initial 2-shot regimen of the mRNAs. And it looks like even more quickly for the boosters after that. So you had this short-lived efficacy where rates of hospitalization and death improved initially for vaccinated individuals. But then once you got past that 6-month period, the rates of hospitalization and death for those vaccinated individuals started going up. And so the pandemic of the unvaccinated narrative looked plausible right after vaccination campaign began. But then about 6 months later, it started looking like it wasn't true anymore. And instead of publishing that data on hospitalization and death among vaccinated individuals, the CDC, and this was reported by the New York Times in May of 2022, the CDC stopped publishing that data. And so one of the things that needs to happen is that those two functions need to be separated, right? We need a public health agency whose only job is to do epidemiology and to have requirements in law that data be made available to independent researchers, right? And they're not responsible for public policy. They're not responsible for public health recommendations. They're just running the numbers and publishing the science. I think that's important, right? If we want to have another public health agency that gives recommendations or makes policy, that should be entirely separate so that it doesn't compromise the scientific function of the CDC.
And if it's going to make guidance that essentially has the force of law or the force of like binding regulation, it should go through the same processes that other federal agencies go through for creating that regulation.
That's right.
Like extensive public comment.
Yep.
It shouldn't be the case that the CDC can just issue a document out of the minds of whoever wrote it, and then all of a sudden, in every court in the country, it's taken as if it were holy writ.
That's right, because science alone, even if you're a brilliant, perfect, unbiased, objective interpreter of scientific data alone cannot give you policy recommendations because it's only one piece of a very complicated puzzle. Like the question of whether or not to close schools, that can't be answered just by looking at COVID data alone. There are so many other downstream effects and 1,000 imponderables that a policy like school closures would affect besides COVID related problems that science alone is incapable of answering. That science is, the scientific data is obviously an important piece of public policy, right? It should be, all of our public policy should be informed by scientific data, but two reasonable people could look at the same set of scientific data and come to different policy recommendations that both of which are reasonable, arguable, whatever. But in an open democracy, those recommendations should be done in a way that involves, as you said, public input, and not just sort of a star chamber of, know-it-alls at the CDC who are making decisions about housing and making decisions about whether or not you can work and is your job essential or not. These are things that should be should be decided in an open and democratic way that involves the usual give and take and push and pull and compromise process that's necessary whenever you're talking about public policy that everyone's going to have to live with.
Well, Aaron, I've taken up more of your time than I promised I'd take, but I'm really glad that you agreed to talk again. It's been absolutely wonderful to talk with you, and especially glad for the good news on the case and the new hope about the case. I'm looking forward to new results, and as things happen in the case, we hope you'll agree to come back next time. Absolutely, I always enjoy our conversations, and we're going to win. I'm still confident we're going to win this one in the end. Thank you, Aaron. This has been Professor Jay Bhattacharya talking with Professor Dr. Aaron Kheriaty for the Illusion of Consensus podcast. Until next time.
Has the dust settled from the COVID policy response? Far from it. The storms are many. Inflation, learning losses, ill health, high crime, broken government services, displaced workers, substance abuse, mass loneliness, discredited science, real estate crisis, censorship, and overweening state power. The world is on fire with war, mass killings, crime, hunger, revolution. The lack of accountability, or even so much as an apology, is a foreshadowing. They'll keep their newfound powers and try it all again. Brownstone Institute is seeking answers, undertaking important research and publishing the results while providing fellowships for dissident scholars who have been professionally displaced. It's not about this one crisis. We urgently need to restore peace, prosperity, and integrity in science and journalism. Visit brownstone.org for more. We may never get to the truth, but we can get closer to the truth. There will be no stopping the efforts.